go live on YouTube. Are there any preliminary matters anyone wants to bring up before we do so? If not, I would again remind everybody that okay, it's my understanding that we are live. This is a meeting of the Judges Advisory Committee on e-filing. I'd like to welcome all of the members of the committee to the meeting, as well as welcoming all of our support staff, including court ops and tech representatives who are present here today. The first item on the agenda is the approval of the minutes. The minutes for the last meeting of the committee, which was held on October 1st, 2019, were previously posted on the website for review. You've had an opportunity to review those minutes. At this point, a motion from a member of the committee to approve the minutes would be in order. Is there such a motion?
So moved, Judge Bellis.
Is there a second?
Okay.
Motion has been moved and seconded. Is there any discussion? If not, all in favor, please signify by saying aye.
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 Any opposed? Any abstentions?
Judge Morgan abstains. I wasn't part of the committee at the time.
That's correct. And I neglected Judge Morgan to welcome you to the committee.
Thank you.
Judge Lisa Morgan, the administrative judge in New Britain and a long-serving judge on the bench of the state of Connecticut, has agreed to fill one of the empty slots on this committee. So I welcome Judge Morgan to the committee. So the minutes have been accepted. And item 2 on the agenda is an update regarding developing policy procedures regarding the destruction of electronic records. And PJ, that item is listed as yours on the agenda.
Sure. So just to bring us up to speed from where we were at the last meeting, at that point in time, we were looking at applying for a grant from the State Justice Institute to have an outside consultant look at our electronic systems, especially in light of a study that had been done, a report that had been done by the National Center for State Courts, and to make some assessments and recommendations as to how we should handle the retention and destruction of electronic records. Since that time, we got the grant. We hired a team from the National Center. There's an RFP, and the National Center was awarded it. And they have, despite all of the foibles of living through COVID, they've produced that. They've done the study and they've produced the report. We received it from them on the 29th of December, and Court Operations is in the process of putting together a team of folks, both from Court Ops and some clerks from the Civil and Family Courts, to assess those recommendations and determine how to prioritize them and any questions or concerns or issues that we see in attempting to implement them.
Okay. Any questions or comments regarding PJ's report on that front? No. Okay, then. Let's move on to item number 3 that has been referred to the advisory committee by the Rules Committee, and that has to do with electronic filings made after 5 p.m. That proposal was submitted by the CBA litigation section back on February 1, 2020, just as the pandemic was breaking. And it's significant to note, as I said, that it was submitted by the CBA litigation section by its then chair, the beloved and late Ralph Monaco. So I know that there are a couple of entities that have some input on this and some knowledge of the background. I will say that my own knowledge of the background of this is that when the e-filing system was conceived and was being planned and developed for deployment, there was a comprehensive discussion by this committee regarding the deadlines by which filings would be accepted by the clerk's office. That's not to say that filings were not allowed to be made essentially 24 hours a day, but they would only be processed by the clerk's office if they were submitted by close of business on the date on which they were filed. And I think that the concept behind that was to replicate in the electronic world what we were doing in the paper world. And it was also motivated by a desire not to give anyone in the system a tactical or strategic edge by granting to them an ability to file paperwork when unrepresented individuals without access to complex tech systems might not have the same ability, thereby putting them at a disadvantage in matters pending before the court. That's my recollection of the discussions before the committee, and it has to be perhaps 10 or so years ago. I think Judge Lager, Judge Bellis, you were all involved during those discussions. Your recollection may be the same as or different from mine. But I don't see anything that's changed significantly between now and then that would cause us to make a recommendation to depart from that practice. But at this point, I'll open it up to the members of the committee for their input on that issue. Judge Bellis.
I agree with your recollection. I know we specifically addressed the difference between what we were looking to do in the federal court. And I think our rationale was that we did not want to disadvantage any self-represented individual who was faced with the same deadline, but would only have until close of business at 5 p.m. should they paper file as opposed to midnight. So I don't personally see any good reason to deviate. It works. I think it works for the judges. And nothing really has changed. And as you pointed out, it doesn't mean that the people who e-file they could still e-file 24/7 essentially. It's just that if they have a deadline for the filing of whatever they're filing, they would need to have it dated by 5 p.m. to get that same date.
Right.
Thank you.
Right. Judge Lager, you have any different recollection or input?
My recollection is the same as yours and Judge Bellis's, that we comprehensively discussed this issue and decided that it made the most sense for all of the reasons that have already been stated, and I don't see any reason to change the rule.
Right. Any other input? I believe that Court Ops has also taken a look at this, I believe, and I believe our Executive Director of Court Operations is on the line, Ty Erickson. If Ty wanted to weigh in at all on this.
Oh, good afternoon, Judge Carroll. I don't have anything to add. I agree with the recollection and the reasoning, and it seems to be working, and there would really be no logical reason to extend the deadline. So just wanted to add our comment. We did review this, and that's what our thoughts are anyway.
Right. PJ, if the committee were to implement a system that would allow, I presume it's largely going to be lawyers who would be able to file and have the filings marked as meeting a deadline to file before midnight. Are there any technical impediments from implementing such a process?
Well, I don't know that it would be an impediment, but there would need to be clear logic as to what the new rule was, and those changes would need to be made and be tested. At this point, a component like that of the system is underlies everything. I mean, that goes back to day one of building e-filing. And so while it wouldn't necessarily be a showstopper, there would need to be clarity as to exactly what rules should be implemented, and there would need to be extensive testing to make sure that that was implemented correctly throughout the system. Right.
Judge Albus.
Thank you, Judge Carroll. in terms of the family division, we have a lot of self-represented individuals. So I think the reasoning the committee had at the outset applies. But I also have a further concern that in family, we have things like TRO applications and emergency custody applications, where the expectation is that they will be acted upon on the day they're filed. And if this new rule were adopted and applied to those matters, the court really wouldn't be acting on them until the day after they were filed, which is not typically what we do. So I think if we were to go this route, there should be some recognition that if it's an application that results in the need for immediate action by the court, it might not happen until the next business day if it's filed after 5 p.m.
Any other input? I think we've pretty much developed a consensus view here. Is there any other input? If not, without the need to call the matter for a vote, I would suggest that we refer the matter back to the Rules Committee with just a brief notation that we considered it here today, that the matter was considered when e-filing was adopted, developed, and deployed. All of the issues that were a matter of concern back then remain a matter of concern today, and it's the opinion of the advisory committee that there should be no current change to the existing rule. Does that make sense for everyone? Okay. All right then. Okay, let's move on to item number 4, which was also referred to the advisory committee by the Rules Committee. It involves practice book section 7-10 and 7-11 with respect to summary process cases. Before we start any discussion on this matter, I want to note a couple of things. Number one, PJ Deek has distributed to everyone several items on this particular proposal, which were submitted by Greater Hartford Legal Aid, particularly Attorney Giovanna Shea. I think most recently it was either Friday or over the weekend, PJ sent out an email received by Giovanna Shea, the Litigation and Advocacy Director of the Greater Hartford Legal Aid. She indicated that she wanted to make the committee aware of the announcement of the imminent February 8th release of a report by the Connecticut Data Collaborative and Connecticut Fair Housing Center on the disparate impact of eviction filings on women of color in Connecticut. She notes that this study is relevant to the legal services proposal with respect to eviction records, which seeks to reduce the amount of time that eviction filings remain on the judicial branch website, in part to attempt to mitigate the economic impact of this racial and gender disparity. She also wanted us to know that the Connecticut Data Collaborative and the FHC report will launch and be publicly available on February 8th. Its findings are discussed in this CT public episode of Disrupted, which is a 35-minute presentation, which can be accessed at the link that was also included in the email that was sent to us by PJ. In addition to that correspondence earlier, Attorney Shea, on behalf of Greater Hartford Legal Aid, submitted comprehensive information regarding their specific proposal with respect to eviction records. It's comprehensive and particularly well documented and supported. It also includes some information regarding how at least one other court system in the country, Minnesota, deals with issues such as this. That too has all been previously submitted to all of you for your review, and I hope you've all had ample opportunity to review and consider the proposal. Before I open this particular issue up for any discussion, let me just make a couple preliminary comments with respect to the proposal and the role of the Advisory Committee with respect to this, which in my mind is a proposal dealing very much so with what I would consider to be a public policy issue. In large measure, the advisory committee on e-filing has never really addressed issues with respect to substantive policy. Rather, the purpose of the committee, in my mind, has largely been to address and implement technical standards and practices with respect to the operation of our e-filing system. Never has the committee, to my recollection, weighed in on or addressed the issue of records retention. Records retention has routinely been an administrative matter or concern for the Office of the Chief Court Administrator. And prior to the advent and implementation of electronic filing and electronic case management, record retention decisions were largely based upon practical and budgetary considerations tied to the storage of paper-based records. And it was largely a matter of the space required to store such records and costs associated therewith. With electronic records, and with electronic storage of those records, these issues are no longer as significant a concern as they were when we operated almost entirely on a paper-based system. And again, my recollection is that where administrative concerns intersected with public policy concerns, the branch would always defer to those policy decisions that were made by policymakers, not by the advisory committee on e-filing. And a perfect and timely example of this right now is the law that was enacted in the last session of the legislature, which deals with the erasure of electronic records regarding certain criminal convictions. That was a decision on which no input was ever requested from the e-filing advisory committee. That was a decision that was driven largely, not largely, entirely by policymakers in the governor's office and in the legislature. And they have enacted law which compels the branch to take certain action with respect to electronically stored criminal records. And I think it is arguable to suggest that the weight of the proposal that's being made here by Connecticut Legal Services warrants input by the legislature and the governor's office in a way that will elicit input from all interested parties on a matter such as this. E-filing considerations really, in my mind anyway, have little to do with the policy behind the proposal. So my review of this leads me to believe that this is a significant policy proposal that's being made by legal aid. There's much merit to it. And I think that the decision ultimately must be made by an entity other than the advisory committee on e-filing. Perhaps the rules committee may want to weigh in on it, and perhaps that may be the proposal that we refer back to the rules committee, that this was a policy issue on which we felt the interests were so compelling and so important that it required input other than from the advisory committee on e-filing. Those were my initial thoughts. I'm sure that others may have thoughts that conflict with mine, but I would be eager to know how other members of the committee weigh in on this issue.
Well, I'll opine. I agree, Pat. I don't think it's in our jurisdiction. And I think we have to treat everything the same, and sort of openness being the touchstone for us. And this would run counter to that. I respect and I understand the policy goals behind it, but I don't think this committee should or can make those distinctions. And I'd kick it back. I don't know if the rules committee should either, but that's not my bailiwick. So. Right.
And the proceedings of this advisory committee, Judge Abrams, largely it should be noted that these are public meetings, but not public hearings. So we generally don't have any forum within which we can solicit input from disparate parties who might have disparate interests in these types of issues. So that's what caused me to come down where I came down. I know that throughout the pandemic, Greater Hartford Legal Services and other legal service organizations in the state were very active with respect to extension of moratoria on the filing of summary process actions. And that activity largely took place with the governor's office, the legislature, and resulted in the issuance of executive orders by the governor imposing those moratoriums. We did not take any policy actions with respect to that issue. We left it, in fact, to the policymakers there. And that's what caused me to believe that at this point it should be left to the policymakers as well. I don't know if court operations or PJ, anyone else had any other input that they wanted to add with respect to this issue.
Hi, Judge Carroll, it's Ty Erickson. Other than, again, to agree with what your reasoning and logic is, we did have discussions within the court operations unit and had some concerns with respect to treating a particular subset of civil cases differently from the other cases that are covered by these two practice book rules, notwithstanding, as I think Judge Abrams said, understanding why the issue has come to the forefront and the concerns related to the issues. But so other than to support your position and your reasoning, I don't really have anything else to add. I don't want to cut anybody else out of the conversation, but that was the discussion that we had within the court operations unit. I don't know if Krista has anything to add. Krista S.
Hi, thank you. Good morning, good afternoon. No, just so just sort of to delve deeper into what Ty said, the conversation that we did have was, you can make similar, again, equally compelling arguments for parties to small claims matters, parties to contract collections cases, parties to foreclosure matters. So we just thought this was something that, while the underlying spirit is, we agree it's an issue, but to carve out, as Ty said, this one subset was something that we didn't think was necessarily just fair to other litigants in our courts as well, who are similarly situated.
And just so the record is clear, Krista Hess is our Director of Court Operations and works with all of our clerks throughout the state. And again, I should also note that, again, to the extent that this is a records retention issue, a records retention issue is something on which the Advisory Committee on e-filing has never weighed in the past. So it would be an unprecedented action for us to start weighing in on records retention issues at this point. So I think that, is there anyone else who wanted to offer any position on this, on the committee or staff? If not, again, I would suggest, without the need for a vote, that we again send the matter back to the Rules Committee with the notation that the matter was discussed, and the consensus of the members of the committee present at the meeting today was that it be referred back to the Rules Committee for the reasons that we've all mentioned here, that this committee does not deal with records retention issues, that the underlying proposal is largely a matter of public policy on which this committee, and perhaps not even the branch, should be weighing in. Rather, policymakers should be weighing in on it. If in fact the Rules Committee has a different view of it, the Rules Committee may elect to move forward with the proposed rule change as submitted by the legal service organizations, at which point presumably they would schedule a public hearing so all interested parties would have an opportunity to be heard. We don't have such a mechanism here in this committee. So if there's no objection, that's how I would propose that we move forward. All right. Seeing no objection, let's move on to item number 5 on the agenda. which deals with filing a motion for removal to federal court prior to the return of the electronic case. That's how it's set forth on the agenda. I think that this has come before us in some measure anyway as a result of an editorial that appeared in the Law Tribune some time ago, prior to the pandemic, I believe. And Judge Bellis, you may have some background and knowledge on this particular issue and may have some input. Is that correct?
Just minimal, because it actually happened in Bridgeport in a case. I suppose it looks like the suggestion is that the defendant be permitted to file the notice of removal in paper form so that they can comply with the federal statute, which requires that the notice of removal be filed in our file within 30 days. I don't know, however, if that's something that's possible. So I would defer to PJ on that. But the issue is that if a plaintiff selects a return date that's more than 30 days out from the service date, which is the date the action was commenced, it's impossible for the defendant to timely file the notice of removal within the 30 days that the federal court requires, because there's nothing to file it in. So I think just a matter of whether it can be done first.
And PJ, did you have any input on that? I know the court ops may have some input on it.
I can certainly provide technical information, but maybe we should hear from court ops first.
Sure. Ty?
Yeah, Judge Carroll, if you don't mind, Nancy McGann, we did have a discussion in the court ops unit, and Nancy McGann may be in a better position to give a little bit more detail to this item, if you don't mind, Nancy.
Not at all.
And Nancy, could you just identify yourself and your role?
Yes, good afternoon. Nancy McGann, Deputy Director for Civil Matters for Court Operations. Just to reiterate what Judge Bellis indicated, it's Section 1446 of the federal rules that require this filing within 30 days. And it's normally not an issue when a case doesn't have a long return date. We have had, since 2018, 4 cases that I'm aware of, because this office centrally handles the remands from federal court. Judge Bellis had one of those cases in Bridgeport where the case had not been initiated yet by the plaintiff, and therefore the defendant couldn't file the notice of removal anywhere. So it's not something that happens frequently, but it does happen. And what we had discussed within court operations was to perhaps create a bifurcated process so that most people who e-file cases and timely remove those cases can e-file their notice of removal. But in those limited situations where the plaintiff hasn't returned the case for filing to court, the defendant can file on paper a notice of removal that the clerk would keep in some sort of folder until such time as the case was initiated in order to comply with 1446 of the federal rules. We anticipate that it would not be a frequent occurrence and overly burdensome to the clerk, but it would preserve someone's right to remove a case to federal court.
Is that, in fact, how it's being handled now, Nancy? Okay. And it has been for some time?
So what we do now, oftentimes we don't know until we get a case remanded to us from the federal court, and we process it here centrally and send it to the clerk so that they can upload the remand documents to the file. If we can't find a case, then that tells us that there hasn't been a case initiated, and we save the remand documents on our system so that if the case is initiated in the future, we have those documents. And we typically notify the clerk that this has occurred. And I think that's what happened in the case in Bridgeport, which was brought to Judge Bellis's attention. Again, it's not a common occurrence, but it does happen. And it's, it impacts the defendant's ability to remove the case under the federal rule. So we think the bifurcated process may be a good way to address that, that would not be overly burdensome to the court.
Okay. Very nice. PJ, was there anything else that you wanted to add?
Sure, just that following up on what Nancy's said, because there is no case in the e-filing system and the request is to allow the document to be filed on paper, it's really not a technological issue as much as a policy and procedure issue. So the e-filing procedures and technical standards right now, page 16 and 17, include a variety of different documents that at certain times need to be filed on paper, and it spells those out. And if the committee found this to be appropriate, we could certainly add this document prior to case initiation, and we'd have to come up with the right language for that as one of those that would be in that situation filed on paper.
Based on before I hear from Judge Bellis and Judge Morgan, based, PJ, on what you just said, it seems like that is the action that we should take as a result of this. So can you at least come up with some draft language that we can add to the technical standards to address the concern?
Certainly,
Okay,
I can work with Krista, Ty, and Nancy, and we'll do that.
Beautiful. Great, thanks. All right, Judge Bellis and then Judge Morgan.
So I just want to make sure I'm understanding it. So that the thought process is just take the paper, don't assign a docket number, don't scan it into the system. It'll just be a piece of paper, and the central office will keep the piece of paper, not the clerk's office in the courthouse. It'll be a centralized file.
I think the intention, Judge Bellis, would be the clerk would keep it similar to a med mal, you know, the extension that they do for the med mal. So it would be, I don't want to say filed, it would be submitted on paper and held by the clerk of the court.
Okay.
Thank you.
Judge Morgan.
Yeah, let me just follow up on what Judge Bella said. And so the clerk of the court has to keep this piece of paper in a file and randomly check on a daily or a weekly basis to see if an action has been returned to court. And let's assume that's done, it's misplaced, it's someone is out for COVID, whatever it may be, and the clerk doesn't find it and file it on a timely basis, and then the case can't be removed. I mean, it seems to me that this is a problem for the Federal Rules Committee as opposed to deal with electronic filing in the states, or maybe at least in the District of Connecticut. But it just seems to be fraught with peril if we're going to have a piece of paper. And Nancy, you've said there's only been 4 occasions that this has happened in the last several years. It just feels like it's a problem waiting to happen, and it's going to catch one of our clerks in the position where it's going to get missed. I'm concerned about it on behalf of the clerks.
PJ, based on the concern that Judge Morgan just raised, and without having had an opportunity to do any research, is there a possible tech solution to this? Some kind of a tickler system or some kind of notification? Name-based notification? Hard, right?
Well, you can use technology to solve almost any problem, but in this situation, because there's no file, and that's
Right.
that has been the types of situation where there's no file yet have come up occasionally in the past. And because there's no file, there's no clean and clear way to put it in the existing system and keep track of it. Like, say, if something was filed, it could be put on the judge's or the clerk's workflow queue so they would see it in the future. But because there's no file yet, there's no case, there's no docket number, I'm not sure how. I mean, we could brainstorm and come up with some external technology solution, but I'm not sure there would be one within the e-filing system that was easy to implement.
Okay. Judge Bellis.
I suppose just an easy paper way around it is you'll give a stamped copy, right, of whatever is filed on paper to the filer, and God forbid, it's misplaced in the courthouse somewhere, the filer will have it. And I suppose that we can also, our clerk's office can electronically scan it into their own computer. It doesn't have to just be on paper. It doesn't have to be e-filed, but we could still electronically keep a copy of it. So I'm not that concerned with it. I assumed that we're going to give a stamped copy back, and that should solve the problem.
Judge Albus.
Yes, Judge Carroll, maybe to follow up on Judge Bellis's suggestion, what if the standard required that the filer, once the case has been returned to court, e-file the stamped copy of the notice that they filed on paper. And then it's not up to the clerk to be checking, yet there'd be proof that it was timely done.
Very good proposal, Judge Albus. Judge Lager. I think you're on mute, Judge Lager.
I think that's a great proposal from Judge Albus, and I mean, I don't believe it's posed a huge problem for the clerks when we hold the extension letters in the med mal cases. And since we're really talking about a very small number of cases, if we just put in the technical requirements that something akin to this may be filed by paper, but it's the responsibility of the filer when the case is returned to court to electronically file this this request to transfer to the federal court, then that takes all the burden off of our clerks, I think. So I don't see this as something that's going to be really burdensome, because it is rare. But for the case in which the filer misses that opportunity to at least give the federal court an opportunity to determine whether they have jurisdiction over the case, because of the extended return date, I think that's a fundamentally unfair for the filer, and I think this is a very easy fix.
Okay, Judge Morgan.
My last observation, I agree with Judge Albus's suggestion, but I would say the only distinction between the med mal cases and this cases is that the med mal cases, when we're holding the paper, we have the power to fix it if we've lost the paper. In this case, we don't have the power to fix it because it goes to a different court. It goes to the federal court, who then remands it because the removal notice hasn't been timely filed. So once it leaves our hands, that to me is a difference. Now, I think it makes sense to have it would make sense to give the time-stamped copy back to the party seeking to remove the case and then put the burden on them. But again, I just am trying to make sure that it's not another burden that we put on the clerks, particularly because it so rarely happens. I think there could be potential problems.
Well, this is what the advisory committee does. We get input from really experienced and knowledgeable judges and staff. And I think we've done that here today. I think we have enough input and some suggestions that we can at least ask that PJ and court ops work with, perhaps coming up with, in addition to our technical standards that may address the issue. And I would ask that we add this to the agenda of the next meeting of the advisory committee for an update. So I thank everybody for their really solid and meaningful input. Item number 6 on the agenda is a report from PJ regarding CFFA, this Civil Family System accomplishments and upcoming releases. So PJ.
Just going to share my screen here. Good. Can you all see that document?
Yes.
Good. Okay, so typically at these meetings, there's some report out of what we've accomplished in the recent past in terms of enhancements to the e-filing in the Edison system, and also what we're currently working on for upcoming releases. So that's what this is. It's been a long period of time, so there may very well be smaller components that I didn't list here, but things that we've accomplished since the last meeting was legal notice by web publication is now done electronically on our website rather than in the newspapers. TROs and CPOs, temporary restraining orders in family and civil protection orders in civil, are now paperless files. Exhibits in civil and family cases are electronic for paperless files. They're uploaded over the internet through e-services by attorneys or by parties. Self-represented parties can also submit them on paper, as they can with because e-filing is optional. And can be viewed online where appropriate, paperlessly. We've expanded the UIFSA case types included in the e-filing system so that the Hague Convention case type cases are included. There were 2 case types for that. Electronic transcript requests, which is slightly tangential to e-filing, but is certainly relevant to the court. Transcript requests, which used to be submitted entirely on paper to the official court reporter's office. Now attorneys, like with e-filing, it's mandatory for them to file them electronically through e-services. And there have already been hundreds of those, even though it just went live on the 3rd of January. So there's lots of use. Parties may request approval for e-filing access by email rather than having to come to the court in person. That happened very quickly at the beginning of the COVID era, and that's been very successful at providing e-filing access and access to their files for a lot more self-represented parties than were e-filing before. It's still not a huge proportion of the self-reps out there, but it's larger than before. Also, parties on family cases can view their file electronically over the internet now without needing to file an appearance. They still need to request and be approved for electronic access, but they don't have to also file an appearance in the case. From a technological security and sustainability perspective, JIS has done a complete with the e-filing and Edison systems and also quite a number of other systems in the judicial branch. Web server replacement, so all of the servers that drive the web applications that we use, Edison, e-filing, etc., were updated in 2020, and then we went back through and updated the database servers in 2021. That was a gigantic project on JIS's part and on ours in terms of testing and ensuring everything continued to work seamlessly. We've eliminated dependency on Internet Explorer on certain kinds of scripting that were not up to new security standards as cybersecurity issues have increased. And we've eliminated dependency on issues that were being caused by Adobe DC. Certainly Judge Albus and Judge Bellis and Judge Abrams and Judge Morgan, anyone who's practicing was experiencing that, where PDFs would freeze on them over the course of last fall. Those 2 projects took a solid 4 to 5 months to get through with Edison and e-filing. They were really large, and we've had an ongoing, slow but steady project of updating and streamlining the online help files or quick cards and manuals for self-reps and also for attorneys. E-filing has been around now for quite a number of years, and some of that material is more up to date than others. So we're trying to make sure that folks who are trying to use our electronic systems are being provided with the best, help information that we can give them. I don't know if there's any questions about what we've accomplished up to now. If not, I'll go into what we're working on next. All right, so things that are in process at the moment. We're working with both DSS and CSSD, 2 separate projects, but very similar, in order to share data where appropriate so that they can be more efficient with their systems. With DSS, it relates specifically to family support magistrate orders. We have transmitted those orders to them as PDFs electronically for a number of years. Now that they're updating their own computer system, what they're looking for is a data feed of the elements of the order so that they can save data entry on their side by having fields in their system be directly populated by components of the order that are identifiable. So that's been a hopefully will be a time-saving project for folks at DSS, and also an accuracy, increase accuracy, less data entry errors. And with CSSD, the CMIS system has for a long time had a feed, 1 case at a time of being able to see some data from the e-filing system. CSSD had asked if they could expand that so they could look at multiple cases and also look at scheduled events from Edison so that they could tell whether upcoming hearings or trials, or especially it's all family cases, were still going forward or had been marked off, and they could then create ticklers for folks in their system, or reminders for folks in their system as to the status of the case, and also then to be able to look at our dockets essentially within their system. So we're working on those 2 feeds right now. The family court, Judge Albus and Johanna have set up a new process that involves tracks and judge assignments. And I apologize for the delay with that, but we're finally getting to the place where we're going to integrate that into Edison. So the tracks will be data elements, the judge assignments will be data elements. And not only would you be able to see that information easily when viewing a case, but you'd be able to, eventually we'll be able to create reports or incorporate that into the caseload reports or anything like that. We're working with JIS, all of the virtual hearings processes that have been created by JIS, the remote justice site. We're looking at ways that Edison, when you schedule a case in Edison, we can automate the creation of the links that allow people to join a hearing and automate them in a way that the right folks connected to a case are able to join the hearing appropriately. That's actually a big project. It involves a lot of new technology, but where the clerks right now and caseflow coordinators right now are having to do those steps sort of manually in two places, schedule the event in Edison, create the virtual hearing space in Teams separately. We're looking for ways to marry those two and save labor. From a technological and security standpoint, we're looking at migrating the entire Edison system from the platform it's been on since 2001 to classic ASP to a more robust one that's sustainable into the future. We've been at that for probably 3 years now, and we're looking at phase 1 of that finally being ready to go forward. It won't affect judges or caseflow coordinators or clerks very much. It's mostly pieces that are more administrative, but that will allow us to then be positioned well to move into the things that are more heavily used by folks in the courts in the coming years, and ensure that the Edison system will be sustainable 10 to 15 years to 20 years into the future. We've looked at enhanced automation for making, processing, and tracking access requests for the Edison and e-filing systems. And the next phase of digital signage, we're hoping to make the signage software more robust so that if a sign goes down, instead of depending on the clerk's office to call us and let us know, the system will notify someone here at Court Ops automatically. We'll get an email and we can just restart it or do whatever's needed without the clerks needing to intervene. So those are some of the things that are coming up and some of the things we've accomplished recently. I'm going to stop sharing if anyone has questions.
I think those are significant accomplishments. PJ, thank you for chronicling them for us and bringing us up to date. If the impact of the pandemic ever starts to subside, maybe we'll be able to convene meetings of this group more regularly, and you'll be able to keep us up to date on a more regular basis on the progress that's being made across the board. So thank you. Any other comments on PJ's report? If not, let's move to item 7 on the agenda, which is a status report on letters filed by litigants in family cases. And that on the agenda, Judge Bellis, you are listed there, and I know that Judge Albus may have some input as well. I know that the mere filing of letters has become chronic, I think, in many family cases, and we were struggling to find ways to deal with that. So what's the report at this point?
Do you want to go first, Judge Albus, or shall I go?
Go ahead, Judge Ellis. Thank you.
All right. So as I recall, I was asked to draft a proposal, and I did sent it to Joe Del Campo, and I know this goes back to 2019, CC'd Judges Albus and Abrams, but who remembers? But I can it's actually very, very straightforward. And so my proposal is just to add a sentence, and I can resend it to Judges Albus and Abrams, but was just to add a sentence to Practice Book Section 4-1A, which deals with the form of pleadings. And my proposal was to simply add the sentence, any paper document subsequent to the complaint that is not in compliance with this section, including correspondence to the court or court staff, shall not be filed in the court file by the clerk. That's it. It's pretty straightforward. And I added my proposal added the by the clerk language at the end, anticipating that a judge for one reason or another might order that the correspondence be filed in the file. And I did not address what should be done with letters that my proposal suggests should not be filed. I figured that retention issue wasn't part of the charge I was given. But I do feel pretty strongly that I said then and I say now that letters to the court, letters to the clerks, they're not pleadings. They shouldn't be placed in the file. And because we're not entirely consistent across the state as to what we do with the letters, you know, the inconsistency is not a good thing. And it even might vary from judge to judge within a courthouse. And, you know, we have, at least in civil, I don't know, Judge Albus, you'll address family, but in civil, we have case file requests that give you all different options if you need to communicate. And there's a box that's marked other. So requested action other, and if there's something that's not included in one of the boxes that are already on the case or request, somebody can mark the other box, put the explanation in the case or request as a form, gets put in the file, and it makes it very clear on the form that everyone has to be certified and sent a copy of it. And so that right there is a big bonus, because a lot of times, as we all know, with the correspondence to the court or correspondence to the clerk, it is not copied on all the appearing parties, and that's a huge problem. So that was my proposal.
Okay, Judge Albus.
Yes, on that last point, Judge Bellis, the Family Division has, since our last meeting, created and started the use of a similar case flow request form. We found the need for it because of the pandemic, when people had more limited ways of communicating with the court. So we created one that has a number of options, including the same kind of other option that you cited. And I'm in favor of the kind of language that you proposed, subject to hearing from court operations about the feasibility of enforcing that. They're the ones who have to receive and process these things. But especially self-represented litigants do tend to include a lot of documents, either separately or with a proper pleading, that are more in the nature of evidence to be submitted at a hearing. And clerks are very good about trying to police that. And I think this is a similar phenomenon.
Judge Albus, I'm sorry if I may, Judge Carroll.
Sure.
Judge Albus, our case file request form in civil not only makes clear that you have to certify it and send a copy to all appearing parties, but there's also an area that asks whether or not the opposing side consents or does not consent to your request. Does your form, do you know, have some similar language? I mean, doesn't drive what you're going to do, but it is sort of nice to know that both sides or everyone agrees to the request or there's not consent.
It does have that general statement at the end as to one of the options, which is something we created as part of our new process. It's a request for a hearing before the next scheduled court event. And that goes into more detail and asks questions about the length of the hearing that you think you'll need and why it can't wait until the next court date and who the witnesses will be. And our procedure with that particular request is that the opposing side has 5 days to respond, because we not only want to know if they consent or don't, but we also want to know how long they think it will take. And it gives us both sides availability too, so that scheduling can happen if the judge decides a hearing should be held without a lot more back and forth between the parties. So either way, the input of the opposing party is either required by the form or part of our procedure.
Judge Bellis, is what you proposed capable of being accomplished simply by amending our technical standards, or based upon your analysis, does this in fact have to go before the Rules Committee and require an amendment to a rule?
I think the gold standard would have it go to the Rules Committee, because, you know, that's where people should be able to look very easily, and it's clear as anything, and it carries the weight of the rule of the court. And that's just my 2 cents. I mean, I suppose we could do it as a technical standard alone, but I think the gold standard would be also to have the rule change.
Okay.
But that's just my own personal.
Is there any issue with respect to a clerk or the system identifying what actually constitutes a letter? In other words, I think I've seen letters that have masqueraded as motions. Is that a concern that that anyone considered? Is it an issue?
Well, I mean, if the filer chooses the e-filing caption, and oftentimes, whether it's an attorney or self-represented party, it doesn't match up, we don't really have any control over that. Sometimes there's an additional description. So I guess that's an excellent question. I guess an answer to your question, if someone is e-filing, they could still file a letter and call it something else. But there's nothing we can do about it, just like people sometimes, misfile whatever documents they're filing.
Okay, well then, why don't I suggest that we, together with court ops, try to come up with some language. You it looks like you've done 99% of the work already, Judge Bellis, but maybe we can have that reviewed by our court ops folks, and either we can bring this back to the advisory committee, or unless there's no objection, once we conclude the language and the drafting, we can send it off to the rules committee. Okay, so we'll just move forward in that way. It concludes the items listed on the agenda. Is there any other business that anyone would like to bring before the committee? If not, I did have a couple of quick closing comments that I think should be reflected in the minutes. Earlier today, I received an email from Judge Berger, who suggested that due to his changed status and his limited schedule of work time under the unfortunate rules that have been implemented as a result of the pandemic, Judge Berger suggested that it might make sense for him to step back and remove himself from the advisory committee. I told him that was entirely up to Judge Berger, but I thought it was important to note for the minutes, as I did in my response to Judge Berger, that Judge Berger has been a part of this committee since its inception, that he truly is the father, or some may say the grandfather, of Edison, and one of the driving forces in the Connecticut bench for the creation of an e-filing system and electronic docket management system. His contributions are many and varied, and we simply would not be where we are as a state today with respect to electronic filing and electronic case management, but for the input from Judge Berger. So I think the minutes should reflect the gratitude of the committee and the bench for Judge Berger's many contributions on this front. I should also note, I was happy to see Judge Lager sign on to the meeting today, because I know that her status is similar to Judge Berger's, and I don't know whether Judge Lager's status will change yet again at any point in the future, but I wanted to note as well that she too has been here from the beginning of the proceedings of this committee, and her contributions, both as a trial judge and chief administrative judge for civil matters, have again been many and varied and absolutely indispensable to the proceedings of the committee. So if I don't get an opportunity to thank you, Judge Lager, in this format, again, I want our minutes to reflect your many contributions and our gratitude to you for your extraordinary career and your extraordinary efforts on this front. So we're all very grateful.
Thank you so much, Judge Carroll. I truly appreciate it.
Well, we appreciate it as well. The same can be said for Judge Ment, who is not on the call today, but the contributions of Judge Ment to bringing the judicial system into the 20th century and now the 21st century simply cannot be quantified. He was a visionary thinker, remains a visionary thinker with respect to court management and court administration. And he insisted early on, number one, that we become tech literate in terms of the deployment of PCs and electronic technology to all of our judges, and insisting that we move forward with all due speed in the implementation of an e-filing system and electronic docket management. So I think the minutes as well should reflect the gratitude of the committee and the bench to Judge Ment and his many contributions. Also, Don Turnbull, who is our Executive Director of Information Technology, retired at the end of last year. And Don was an ardent supporter of all of the efforts of the e-filing advisory committee and all of our technology initiatives over the years. His contributions as well should be noted for the record, and our gratitude should also be extended to Don for his many contributions. I should note as well that replacing Don as Executive Director of Information Technology is somebody who is well known to all of us and who has also been involved in the proceedings of this committee since the beginning, Lucio DeLuca. And we're happy to have you here, Lucio, in your new role as Executive Director of IT. And you bring with you, and I would ask that Dibby activate his video, you bring with you one of our most talented tech specialists in your division, Dibby Kundu. We're happy, Dibby, to have you here, and we look forward to your contributions at all of our meetings in the future. You have been at the core of every major tech initiative that we've undertaken since I've been on the bench, and your skills and your talent and your input are well known and most appreciated by all of the judges with whom you've interacted over the year. And finally, although we mentioned it earlier, to fill one of the vacancies on the committee, I'm really very happy that Judge Morgan agreed to fill that role, and I welcome Judge Morgan to the committee as well. And I think that takes care of all of the closing comments that I wanted to make. I don't know if anyone else wanted to add anything. If not, I think that we can declare the meeting concluded, and I thank you all for your contributions today. Have a good day, everyone.
Thank you.
Bye, everyone.
Thank you.